the community is local, and particularly this association community is very strong, and this is a great opportunity for us to demonstrate leadership throughout the state. So I'm a lawyer. I'm with this law firm, Burr, Forman, McNair. There's a little bit about our firm. You might recognize some names like Sarah Robertson, Carrie Griffin. We've been doing residential real estate closings for a long time. I'd bet we've probably done more than any other law firm in the Hilton Head, Island Bluffton area. We've been around since the 70s and have always, offered to help the association whenever we can. So we're happy to do that. But that's about the firm. So before we get started, we're thankful to have the ability to have a tremendous amount of brokers and agents all come in on a call all at once. But we do not ever want anyone to even think that we at one point ever talked about something that could be even mistakenly construed as an antitrust violation. So we are not going to be talking about commissions. We're not going to be talking about boycotting property. We're not going to be talking about price fixing or anything like that. So as long as you understand that, keep that in mind when you're typing in questions. But we're going to get started. So this presentation really has two major parts. One is we're going to talk about the CARES Act, and then we're going to talk about some legal issues that relate to our contract of sale and to the recent addendum that the association just adopted that relates to COVID-19 and a few other practice tips during stay-at-home orders. Hopefully, we won't have to to do that for much longer. We'll talk about that later. But first, the CARES Act. So the CARES Act is an 800-page long piece of legislation. I have no idea how all of Congress could read all that before they voted on it. Not going to ask questions there. But what happened is that it created a lot of different programs. So we're not going to talk about every program. We're going to talk about a few of the programs that specifically relate to brokers and agents, okay? So one program that is going to impact almost all of us is that we're all going to get a stimulus check. So if you make less than $75,000 per year, you're going to get a check, a $1,200 check. The government is literally cutting checks. You might have already gotten yours. If you haven't, one might be in the mail. Now that threshold is bumped up to $150,000 if you're married and filing jointly. And that the value of that check increases by $500 for each dependent child you have that's living with you. Okay, so that's good news. If you make just over that threshold, you're still going to get a check. It won't quite be $1,200 or $2,400 if you're married, but you'll get a smaller amount of a check, but it'll finally phase out to zero, and you won't get a check if you make over $99,000. So 80 million checks, unprecedented. This is the first thing that's coming out of the CARES Act. So now John,
let me just interrupt you a second on that portion of that. The IRS just announced probably last week that those that want to have a direct deposit, there is now a link under the IRS website that they can go on to put in your checking account or bank routing and information to get that check directly. Otherwise, I'm understanding checks are going to be written, but probably not till July if they're mailed out.
Gotcha. Well, yeah, thanks, Gene. And when's the last time you've ever heard of the IRS letting you know they're going to give you money? So they're unprecedented times, no doubt. So,
right.
The next program, so they have the stimulus check program. The next program we're going to talk about is a PPP. You've probably heard a lot about the Paycheck Protection Program. You probably heard a lot about how the funds ran out. And then just recently, the Senate and the House came to a deal where they're going to replenish the funds for PPP. And all the politicos on Twitter are saying this program is going to benefit small businesses more than the last program. So that's good news for us. You might be thinking to yourself, well, unless I'm a broker in charge, why do I care about PPP? Well, the thing is about PPP is that you can apply as a sole proprietor or as an independent contractor. So this actually applies to most realtors, most sales agents, okay? So to be eligible, you have to be running a business with 500 or fewer employees, and you have to be able to certify or represent to the lender that you are experiencing financial hardship such that you cannot make payroll obligations, or if you're a sole proprietor or independent contractor sales agents, be able to pay yourself like you normally would in a normal market situation. So, so what they're going to do for agents, for example, they're going to take your most recently filed tax return, and they're going to ask you what the rolling 12-month average was for that most recently filed tax return. So if you filed for 2019 already, they're going to use that as their benchmark. If you haven't, that's okay, because another thing the CARES Act does is allow you to file and make payments, make tax payments, and they've extended that deadline from April 15 to July 15. So if you haven't filed yet, they're going to use the 2018 returns to determine, you know, what your payroll would be for your own personal business. Now, also, if you have an assistant, then you can count that person, and if that assistant is a true employee, then you can count that assistant in your payroll costs. So brokers and charges, if you've got employed staff, then you know those will qualify for payroll expenses. And also, you know, but if your assistant is an independent contractor, they wouldn't fall under your application, but they could file their own PPP application. So so that's just some stuff that applies to some businesses about PPP. But I'm going to keep rolling. So you can use these funds. You know, the big thing is for payroll, but you can use them for a few other things as well. I've listed those uses that you can apply these funds to once you get the loan. So this is a loan that carries a 2-year term and 1% interest. So there's some confusion there. At first it was 0.5% interest. Now it's 1% interest. But the big deal about PPP is that the loans are forgivable if you use them for certain reasons. So I'm going to go back to the prior slide. You can see in this slide, this prior slide, you can use them for all those things. But here's the big slide that you want to pay attention to. You can actually get these loan funds forgiven if you use them for these obligations. So so if you want to explore PPP, this could be a good way to float through the recession and not have to actually pay the loan back. And in fact, it's not going to be taxable income when it's forgiven. So that's huge. So when you're applying, the lenders are going to make you to ask you to make certain representations. The big one is, are you, have you, been negatively financially impacted by the virus? And that's just a good faith certification that they're going to make you represent when you apply. I think what's even more important is what they're not going to ask. So they're not going to ask if you've tried to max out other form of credit elsewhere. They're not going to ask you to do a personal guarantee. They're not going to really ask for any collateral. So this is a really, even if you can't use the funds for the stated purposes, it's really not that bad of a 1% loan in that right as well. If you have other business obligations that don't fall into those uses, keep in mind though, at least 75% of the loan proceeds that you're eligible for must be used for payroll. So be sure to stay within that guideline. So the next program, we've talked about stimulus checks, we've talked about PPP. Now we're going to talk about EIDL loans, EIDL loans. So these loans have been around for a long time. They're actually used for disaster relief. So for example, businesses can apply for a disaster loan if a hurricane comes and harms their business and their ability to make money. But this is unprecedented because really the whole country is under an emergency declaration right now. So everybody can apply for these loans. The new thing that the CARE Act did for the EIDL loans is that theoretically, and I'm going to get to that, if you apply for a loan, one question on that application is, do you need $10,000 immediately to get by? And if you check yes, they will award you a $10,000 grant. Yes, I use the word grant. I didn't use the word loan. This is a grant that the idea is you don't pay back. So this is a grant that you would get. And the way the CARES Act is written is that you're supposed to get that within 3 days. Now, I've been getting a lot of calls that people have applied weeks ago and they still haven't gotten their advance grant. And to be honest, what we learned on a call yesterday with the Chamber of Commerce is that the SBA that processes these loans is totally swamped, totally backlogged. We learned that they've processed more loans in the past 14 days than they have in the past 14 years. So they are just totally swamped with applications right now. So don't give up hope if you haven't heard from them, even though theoretically the CARES Act is supposed to get you those funds within 3 days. That's just the $10,000. You can apply for more than $10,000, and that will be a loan. Now, the loan is a pretty fair loan. I'm not sure that most people on this call will qualify for a $2 million loan, but a lot of people might need more than $10,000 to have their business get through the recession. So these loans can have up to a 30-year term, only 3.75% interest. So this is all good news and designed to help small business, sole proprietors, and independent contractors. If you are a property management company, okay, your loss of rent is business loss. Okay, so keep that in mind. That might, even though loss of rent isn't really payroll, you might be able to use idle funds to help you get by. And now idle funds are not forgivable like PPP. So idle funds aren't quite as great as PPP. But if you really need, if you're not sure your business is going to make it through the year, you want to apply for one of these loans. Okay, and it really is first come, first serve. You've heard a lot about certain borrowers getting preferential treatment by certain lenders, and we are told that with the new replenishment funds that are coming in, that there are rules that lenders won't be able to do that. So go ahead, if you think you might need these funds, get your application in now. If you apply for PPP, don't let that stop you from applying for EIDL. Okay, so you can actually obtain both types of loans. And if you do that, just make sure that you don't use the funds for the same purposes. Now, your strategy is you want to use the PPP loans for payroll and other things that are forgivable first before you dip into the EIDL loan. And what we've been recommending to our clients is that, hey, if you find yourself in a position where you've got both of these loans, you might want to even create 2 different business accounts just so you can properly account for how you're using those monies, because you better believe it, there are going to be some audits after all this is said and done. So you really want to make sure you have a paper trail. So,
John,
all right, so we talked about stimulus checks, we talked about PPP, we talked about idle, and now we're going to talk about unemployment.
But wait, first, can I stop you, John? I got a couple of questions, and let me just make a couple of comments. Someone is asking you, Leland is asking, you have to have a business account, otherwise you cannot qualify for, I think she means these loans, or he means these loans. So do you have to have, an S Corp, or, do you have to have an LLC in order to qualify? Some realtors operate under individual LLCs, and some just operate very individually and don't have any corporation.
So the CARES Act says that sole proprietors may apply for these loans. So a sole proprietor, that typically means that it's a business that doesn't really have an entity, right? So now it can also mean an LLC where you're being taxed as though you were a sole proprietor. So you take advantage of that. But my understanding of the CARES Act and my interpretation of the CARES Act is sole proprietorship may apply. So I wouldn't let that stop you from applying if you think you need those loans.
Right. So a couple of things we've been telling the realtors through South Carolina Realtors is regarding these is number one, we really recommend everybody speak to their CPA. Everybody's financial
Absolutely.
situation is different. CPA or accountant to be sure that they're, they understand exactly what they're doing and what any ramifications could have to your impact and your taxes. And the second thing is what John just said. Record keeping is going to be vital through all of this. So we really make sure all of realtors understand that if you get these loans, you really keep very, very good documentation on where they're spent, how they're spent, when they're spent, and keep that in your records for the future.
Absolutely. Absolutely. 110% agree. So, and of course, I don't pretend to be a CPA or a financial advisor, but hopefully this is raising some folks' awareness of the available programs under the CARES Act.
So what does someone do when they go to apply for these loans and the bank is denying them because they don't have an account at that bank? Has that been settled now?
Right. So my understanding is that the reason why this question is coming up is that, first of all, certain lenders first of all of them are swamped with applications right now.
Right.
And then the lenders are prioritizing their existing customers.
Right.
So if you don't have an account with them, you might get feedback from a lender saying that, okay, we can't take all the applications, so we're going to prioritize our current customers. So if you don't have an account with them, then we're not even going to fool with your application. Now, the pending, replenishment bill that is headed to the president's desk is said to have corrected some of those issues to make it more small business friendly. So hopefully that will be resolved. I have not reviewed that legislation. I think it's probably another 800 pages long. I don't know that for sure. But hopefully those issues will be resolved. And that's a good point. So for the PPP loans, the SBA isn't actually processing those loans. They've partnered with certain private lending institutions to help them process all these loans. So you are dealing with a private lender in this instance, even though it's SBA certified. Right. So you do have to kind of deal with that private lender's bureaucracy. If you're striking out with that one, try to find out if there's another lender that's that you can get a loan from.
Okay, and over the last few weeks, we've been sharing in our weekly the list of all the banks that are working with under the SBA that you can utilize in South Carolina. But one thing that didn't come up, and there's a question here, and then I'm going to let you go on, John, with this is, can you use the loan money? It was talking about payroll and rent and operate in some operations. But how about if your car is under your business? Can you use it for a car payment? I never saw that come up.
Yep. So for PPP loans, that would not be a forgivable use. That doesn't fall into this payroll, interest, mortgage, rent obligations, or utility obligations. Even for the list of available uses. Yeah. You may not be able to do that, but for an idle loan, that is designed to assist with to helping businesses get by. So you may not be able to use PPP funds for that, and the idle is less favorable. It's not forgivable, but it does carry a 3.75% interest rate, which is better than my mortgage, to be honest. So, and that's a secured loan, and this is not a secured loan. So. I hope that answers the question.
Yeah. Well, again, I would check with your CPA at least on that before you make that consideration. So let's go on to unemployment. That's another hot item for our realtors.
Yes. So typically realtors, don't even think about unemployment because you're not an employee. Why would you think about unemployment? The whole concept is that you're a salesperson and not, a traditional employer-employee salaried. So the CARES Act changed that. One other program under the CARES Act is called Pandemic Unemployment Assistance. And one thing that falls under that PUA umbrella is that sole proprietors and independent contractors that would normally not qualify for unemployment benefits are now able to qualify. And there was a big question mark as to how this is going to work, because typically, you know, an employer is paying unemployment insurance. And so who's paying the employer side of this? And the answer is, this is coming out of the U.S. Treasury. This is federally funded legislation. Now, I say federally funded, it's federally funded, state executed. So the state, South Carolina Department of Employment and Workforce is actually going to be the entity, the government entity that's processing your application. But basically, you know, the idea is if you're a realtor, you can apply for this, and then you can get what you likely would have otherwise gotten on a traditional employer-employee relationship. And in addition to that minimum amount, you get an additional $600 per week. That's that last bullet point on the screen there. So this is a good benefit to, you know, if you're really struggling to pay bills right now, this might be something worth looking into. Now, unlike the PPP forgiven loans, this, and again, I'm not a CPA and I don't play one on the internet, but the unemployment benefits will be considered taxable income. You know, the idea is that you would have earned this income anyways. So this is going to be taxable. This is going to be taxable income. So be sure to talk through those issues with your CPA. Also, the president of the CCAR up north asked this question, which I thought would be good to share with the group. You know, if you currently qualify for the premium, tax credit that helps defray some costs associated with government marketplace, medical insurance, and things of that nature, if this $600 a week is going to kick you over the threshold, then you may not qualify for that medical insurance benefit. So keep that in mind too. That's probably only going to apply for a very few people in the state, but something to be cognizant of and talk through with your CPA. Now, can you apply for the PUA benefit but still continue to sell? The answer is yes. So if you're collecting the unemployment benefit, that does not forbid you from working. So you can actually apply for partial unemployment under this new CARES Act PUA, and then all that will be, you know, taken into consideration, you know, when you apply. Keep in mind that, you know, if you're talking to your friends about this who may not be realtors, if you can still telework, then you're not eligible for PUA. So keep that in mind. But, you know, if I was representing a realtor, I'm going to say, look, you know, we can't just telework. We've got to show houses. We got to be, you know, we've got to be out in the field to get our job done. So, so I wouldn't let that stop you from applying for these benefits. So I had another question, and again, I'm not a CPA, but the question was, if I apply for PPP loans, does that stop me? Am I now ineligible for applying for the unemployment benefits? And there's not, to my knowledge, there's not a whole lot of clear guidance on that. But I would say this: the PPP is supposed to assist you with your payroll. So if you are getting PPP funds, and that covers a portion of your payroll, and then you, as the employee of your sole proprietorship, applies for unemployment benefits, then I think that that is going to reduce the amount you might be eligible for, because theoretically that payroll expense is going to be, you know, included in their calculation. Now, are they going to ask you if you are have applied for PPP? Probably not, but you better disclose that, because if audit season comes around and they see that you didn't disclose that, then you know that might be bad news. So I'm going to move on to student loans.
I'm just gonna. Someone is asking this question, and here a couple of things, and I do know already the answer to this, and let me just give a couple of things on unemployment. So they're asking, so the individual realtor is applying for unemployment. There is a section that's asked, who is your employee? or who is your employer? Who is your employer? Individual realtors should not use their affiliated firm.
Right.
So a lot of realtors are filling that in. Then their brokerages are getting, the documents from South Carolina due, and they don't know what to do. So any brokers on the call, I sent this out the other day, that if you get a documents from the South Carolina Department of Employment and Workforce regarding one of your independent contractors, just return it saying independent contractor. They will follow through and get that correct. So individual realtors should be putting either how they file their taxes, their business taxes each year. That's what they should be putting in there. Second thing, I want to make sure that everybody will watch the announcement from South Carolina Realtors. Will probably come out this afternoon. They will be having the attorney from the South Carolina Department of Employment and Workforce, or South Carolina do, with a webinar on Tuesday of next week. So watch for that. I think that's going to be very, very helpful and informative. That was a little, like John said, it came down from the federal. The local state was not prepared for that in any way, shape, or form. So that's been a little bit of a struggle. So just for information, I think that answers the question. They should be applying under their own name. That is correct. Okay.
Great.
All right, John, continue.
Okay.
Loans.
All right. So another program that the CARES Act talks about that I think may apply to some agents are student loans. So this doesn't apply to all student loans, but certain student loans that are owned by the Department of Education. It's going to suspend your requirement to make payments for the next 6 months. Interest will not accrue for those 6 months. And, if your particular student loans aren't owned by the Department of Education or otherwise don't qualify, one thing you can do is to consolidate your student loans into one that is owned by the Department of Education. But again, talk to your CPA, make sure you understand the pros and cons of doing that. It may have negative ramifications as well, but if you really want to take advantage of the 6-month grace period, if you will, then that's something to think about. Also with the CARES Act touches on retirement accounts. So you have the ability this year to take out up to $100,000 out of most of the common retirement accounts, including IRAs and things like that. And you can avoid the traditional 10% early withdrawal penalty. Now, if you take this out, it's going to be considered taxable income. The good news is that you can pay that amount over the course of 3 years. So let's say if you did take out $100,000, you don't have to pay the taxable income on that $100,000 all in 1 year. You can spread it out over 3 years, or you can just choose to pay that back into your account over the next 3 years, and then it won't be considered taxable income, right? So if you use it more like a loan to yourself, then that would not be taxable income, but you would need to pay that back into your retirement account within the next 3 years. And again, talk to your CPA about that. So that was sort of my very bird's eye view of the CARES Act. I know Gene's probably been on like 20 or 30 of these webinars and probably knows more about the CARES Act than I do and most others do. So Gene knows I'm only touching the tip of the iceberg with all this, but I thought particularly realtors would find some of that information useful. But now we're going to dip into the legal talk about our contract of sale and things of that nature. So the big question is, does COVID create an act of God or force majeure situation such that my buyer can walk away from the deal? All right, so the language of the contract controls here, right? And our contract is different than the state form. It's different from forms in other states. And our contract does not have force majeure language in it, okay? So that's by design, right? So we want to keep deals together if we can. And now my understanding is that years ago, there was force majeure in there, but the current version of the contract of sale does not contain this act of God language, okay? So COVID-19 does not create an excuse for a buyer to walk away from the contract. So here's what I'll say about the addendum. For folks already under contract, for folks already under contract, nothing changes, okay? Nothing changes. The COVID-19 form that the Hilton Head Area Association of Realtors adopted is for folks that have not yet gone under contract, because weeks ago there was some fear that buyers, for example, wouldn't be able to even apply for financing, for example, due to lockdowns and shutdowns and things of that nature. Now we're learning now that a lot of that, is likely not the case, because lenders are still functioning, obviously. But for a variety of issues that could come up that would spook a potential purchaser. So we wanted to come up with that special COVID-19 addendum form to build some purchaser confidence that they're going to have plenty of time to do their due diligence while under contract. Now, if you have parties to a contract who are already under contract, but both parties want to amend the terms of the contract, we already have a form for that. We've got an addendum form. We've got a standard addendum form. So use that. The COVID-19 addendum form was designed to build purchaser confidence if needed. And the reason why we did that was because, unlike the state contract, the 2020 state contract has a traditional due diligence box you can check, instead of the repair language that we have in Section 8 of our contract. So, since we don't have a due diligence, and since we were hearing that a lot of sellers were having trouble getting their homes sold due to the market uncertainty, we came up with that addendum. Even the addendum doesn't create a due diligence period; it just creates time extensions if needed. So it's still more, even with our COVID-19 addendum form, it's still more conservative than the state's, Form 310. If you're not sure whether to use the COVID-19 form, call your closing attorney. Better yet, ask. These closing attorneys, they're very happy to be able to work with you right now. So if you need them to draft up special language or whatever you need, the point I'm trying to make is, we have this COVID-19 form available to you if needed, but do not create your own addendum, right? So we want to stay away from the unauthorized practice of law. And my managing partners might be upset with me for saying this, but this is a saying that I like to tell folks sometimes. And I told them when I did the legal hotline in Columbia, I say UPL equals SOL, right? So unauthorized practice of law. And you know what SOL means? It means sorry, out of luck. That's what it means. And the legal hotline can't help you. LLR can't help you. So when in doubt, just get your attorney to draft up addendum terms. But we do have this COVID-19 form addendum available to you. Now, SCR is instructing associations who have adopted the state form to not use any COVID-19 forms. So if you hear things to that effect, keep in mind they're using a different contract than what we use here in Hilton Head Bluffton, okay? So if you see a video of Nick Cremitis or even me, if I'm talking to another association, then that issue might be a little different. But again, we don't want you to commit UPL. Of course, you don't want that either. And this bottom bullet point here. So we have seen a few specific COVID-19 issues come up. But the bigger issue that I've been seeing with my contracts is that there's really a buyer that doesn't really point to COVID, but is now all of a sudden putting every term under the contract under a microscope. Like, oh, well, seller is refusing to pay this $25 transfer fee or administrative fee that the POA charges. And now since they're refusing to do that, I want out of the contract. I had that happen to me on closing day, y'all. So we don't want that to happen. So stay alert for issues like that, okay? And stay alert for if you suspect that a purchaser is getting spooked because of that, make your closing attorney aware of that so they can try to help you manage that on the front end. And if that was one of our participants' closings, then I know that person is shaking his head too. So now don't forget about fair housing and HIPAA. So it wasn't one of my closings, but another attorney in my office had a closing. It was a Sun City closing where the seller tested positive for COVID-19. And the question was, well, do we need to disclose that to the purchaser? Okay. So now, thankfully, in that case, the seller really just felt bad about everything and really wanted to do the right thing and to be full disclosure with purchaser. And even if, was willing to risk if purchaser was going to get spooked by everything, just really wanted purchaser to be informed, which was good. So, but don't take it upon yourself to go ahead and disclose that. Okay. Get that in writing. Get that in writing from the seller if they're okay with you disclosing that. Because look, we're not doctors. We can't release medical records, things like that. And also it could potentially be viewed as a fair housing issue. So we're going to have more and more positive cases so that I can see this issue coming up more and more often. So for property managers, this is not a rent holiday, not a rent holiday. So I stole that cheerleader move from Byron King in a state association webinar. But his point was true. He probably said this is not a rent holiday 30 times. You're hearing on the news right now that, hey, evictions are stayed for the next 60 days or foreclosures are stayed. That doesn't mean your tenants get a free pass and it allows them to not pay rent. You're still required to pay rent. Now, if a tenant comes to you as a property manager, that doesn't stop you from trying to negotiate and enter into some type of payment arrangement that's favorable to both of you. And I know, you definitely always want to be kind to others. That's the way we are in this community. But you always have to juggle that with, look, you're a licensee and you've got to put your client's best interests in mind when you're communicating with tenants. So, if you're not sure with how to handle it, call your attorney, but this is not a rent holiday. That's supposed to build your confidence in the event you're approached with a tenant who's having trouble, and hopefully you can work something out with that tenant. Hopefully you really can. So, this is all things we've talked about, but going back to the fair housing and HIPAA issues, there is some debate in the legal community right now as to whether or not you should disclose a COVID-19 positive to other tenants, say on the, that may live on the same floor or the same building or things of that nature. Because if, on the one hand, if you don't do that, you could be exposed to like personal injury claims, right? But if you do that, then you're potentially exposed to fair housing claims, things of that nature. So, it really may come down to a fact by fact, case by case analysis. So it kind of depends, if you can access the unit from the outside, that's one thing. If you have to go through a lot of common areas to get to your unit, that's another thing. So call your lawyer if you're faced with that challenge. Vacation rental management companies, oh man, you guys are really taking one on the chin right now. I'm really feeling for you right now. I've been working with many vacation rental companies throughout the South Carolina coast who are struggling with municipal level travel orders. And, in a nutshell, Hilton Head at first banned everything, and then they walked that back and adopted the governor's executive order. Now, the executive order says no new reservations. So if you had an existing one, that's okay. But you don't have to cancel an existing one, which differed from the Hilton Head ordinance that has now since been repealed. So that's good news. More on vacation rentals, just because that's somewhat unique to our market, that you may not get this information as much from, say, state and NAR. But in regards to tenant deposits that you may have collected 6 months ago, the South Carolina Vacation Rental Act is an act that governs what's supposed to be in your vacation rental agreement with tenants. And the act says that that you may collect non-refundable deposits so long as that's clearly disclosed in the agreement that they sign and agree to, that the tenant signs and agree to. Now, am I advocating for you to not, pay back a tenant who you think you can work something out with? No, but I say that to build your confidence, because again, as a licensee, your job is to think about your client, the owner of that unit. And maybe you can, instead of paying all of it back, maybe you can work out something like a credit to be used for, for that tenant to come visit at a later date or something of that nature. But keep that in mind. Now, the one thing I would add to that is if your agreement has force majeure language that might be pro-tenant, that could trump, the act. And if so, in the agreement, if it says, due to some act of God, and landlord can't, provide access to the unit due to a travel ban, and the person's traveling from a CDC hotspot or something of that nature, then that may change your obligations there. And I know some property managers participate in guaranteed payments where, basically the property management company pays owner a flat fee on a month-to-month basis, and property management company collects as profit everything beyond that flat fee. Well, now, of course, nobody can make that guaranteed payment this month, but look for that force majeure language in your contract with the owner to see if you have any leeway there that might be able to assist. Call your lawyer if you need an analysis. So also, real quick, LLR extends all continuing education and license renewal deadlines to September 30. So keep that in mind. Of course, there are payments that go along with renewing your license. So really, that was designed to help people out who may not have a lot of money right now. So you don't have to renew your license until September 30. In regards to our business, hopefully we won't have to deal with stay-at-home orders for much longer. So these stay-at-home orders are typically tied to the governor's state of emergency. So when the state of emergency is over, then that's when the stay-at-home orders are over. There is some talk that now that Governor McMaster is already started to open up some retail shops and things of that nature, the emergency, from a legal standpoint, the emergency may be over possibly as soon as the end of the month. But until then, keep in mind, real estate is essential, so that's good. Now, most other states are identifying what businesses are essential, and basically they're saying that like only these essential businesses can operate. But our governor did the opposite and was more business friendly, in my opinion. It basically identified all the non-essential businesses. Barbers were included in that, which is why my hair is a little crazy right now, a little Kramer right now. But yep, exactly. But thankfully, due to Jocelyn's efforts, due to Lindsey Jackson's efforts at the state level, our advocacy efforts really, persuaded the governor to make sure that that real estate was essential. Now here's a couple of problems to think through. So during a stay-at-home order, my seller wants to stop in-person showings, but let's say you don't. Well, first of all, NAR right now is really hoping that you will try to show your properties virtually during this time. And most listing agreements do give you a lot of leeway to determine how the property is marketed. I mean, that's exactly what your job is. But for showings, the client generally does have control over if and how the property is shown. So keep that in mind. If your seller needs you to stop closings, then they're in charge there. And be sure to explore virtual closings. I've done presentations on virtual showings, not closings. If you use virtual content or use media and photographs and video to assist you in selling the property, make sure you've got copyright control over that. I've done presentations before about listing photography and copyright issues. Happy to talk more about that later. My seller wants me to hold open houses during this, and you're like, oh my gosh, I don't want to hold open houses. Well, NAR is giving you some confidence there. You can tell your client that, look, you know, we're being told from the National Association of Realtors that we're being urged to only do virtual showings. So if you don't feel comfortable doing open houses right now, then use that, keep that in your back pocket. And also keep in mind, even though we're essential, thanks to Jocelyn and Lindsay, you know, the governor's executive order still limits group gatherings to 3 people. So if you are going to be doing the showing, then there's really can only be 2 other people with you. So keep that in mind. You know, in regards to, you know, COVID-19 screening, so we've gotten some questions about whether or not for anybody you show a home to, if you need to take a survey and say, look, can you sign this saying that you're not positive before we let you inside the home? I'm not really sure. I'm not really sure how enforceable those are. I mean, first of all, this is self-reporting. So how much can you really rely on that? A lot of folks might be positive that don't even know it. So it's not really going to solve any legal issues. It's not really going to solve, you know, it's not really going to protect you from a whole lot of liability there. You know, but if you do that, if you're more comfortable doing that, you please do it for everybody you show the home to. If you pick and choose who you give that form to, that could definitely be a fair housing issue. So if you want to incorporate that in your practice, then make sure you give that form to everyone. You know, from my standpoint, I'm not sure how enforceable that form is anyways. So why even start the practice? But that's a business decision. All right, should I use a COVID-19 hold harmless agreement to protect myself? So I got this question from a realtor, and there's a lot of discussion in the legal community about this right now. NAR is advising that they're likely not effective because, you know, even if someone discovered that, you know, that they caught COVID-19 because you let someone in the house to show the house, and then they came in later and showed the house, you know, that is such a tenuous argument that I'm just not sure how you would prove cause and effect there. There's so many different ways you could have caught it, and there's no real time, you know, there's no real timestamp on when you caught the virus in the event you do. So, so I'm not really sure how effective those would be. But, you know, if you're on top of a lot of webinars, then you might hear differently from another attorney. There's discussion on that right now. All right, so fine. I guess I'll just show the property virtually. But what I'm sure there's something that the lawyer is going to bring, you know, to inform me about with those. I'm sure there's a pitfall there too. Well, yes. So it's always been legal to sell property sight unseen, but and that hasn't changed today. But now more than ever, make sure that your media, your photos and your video and your drone and your virtual images that you're using do produce an accurate representation of the home. So if it's photoshopped, or if you made it look like a little bigger or a little nicer, or, you know, want to stay away from that, particularly right now, because you don't want that to come back and bite you and say, oh man, like I got into this home and it looks nothing like the video you showed me. All right, so as far as property managers, you know, tenants in general can't prevent you from showing to future tenants. But if that tenant is quarantined due to testing positive, you're in a spot there because you really can't evict them right now, and they are under a quarantine order. So you might be in a spot if they're claiming that they have tested positive for COVID-19. Yes, we have a whole slide on bidets. NAR has published an article I found hilarious. You know, just Google, find it. That talks about how some agents throughout the country are using bidets as a way to get creative with their listing notes on the MLS and things like that. Because as we all know, that's a hot commodity right now. But I think the greater point is, like, think of ways that you can be creative in this unprecedented time, because now really is an opportunity to make a name for yourself. And also, you know, a lot of folks are saying, man, everybody wants liquid assets right now. It's hard to sell right now. And in fact, a lot of the mortgage brokers, people that process refinances, are really doing well. Some may tell you that they're doing well right now because everybody's trying to cash out liquid assets. But look, that may not be a bad for sales either. Like, you know, if somebody really wants liquid assets, they can downsize. You can always upgrade later, right? So, so just a few little, you know, fun little tips to keep in mind when you're out there selling. So, you know, in Beaufort County, thankfully, we are an e-record county, so not every county has electronic recording. Keep that in mind when you're referring, you know, when your client is asking, okay, well, who are the top 10 real estate closing attorneys that you would recommend? You know, you might want to find out which ones are up and up on e-recording, because otherwise it might be difficult to get something recorded right now. You know, in general, as you know, with DocuSign and everything, electronic signatures are fine. We still need those wet signatures on things like mortgages and things that are getting recorded. So even though we do have e-recording, you still got to get that wet signature for some documents. So a lot of folks are doing like curbside closings where they'll have a notary public and a witness right there, and you don't even need to really get out of your car. But you know, as far as electronic notarization, you know, federally, there's legislation that has been enacted that basically gives a template for states to consider using if they want to go, you know, adopt electronic or remote notarization. A lot of states have done that. A lot of states have done that on a temporary basis, like, hey, just during the crisis, we're going to do e-recording, but then we're not. South Carolina, there is a bill moving through the House. As of last week, or actually as of yesterday, it was in the House Judiciary Committee. Still, it's been there for some time. You know, my friends are telling me that that bill is getting some pushback, so it may end up being stuck there. But I know Lindsay, Jackson, and Jocelyn are working on trying to fix that. So, so that's really all I know about the South Carolina status of electronic notarization. But those are some of the cool people I work with in my office. We've got an office in Bluffton, one in Shelter Cove. And this is some, you know, when you have a business development team, they like to add all these really cool slides that have a map of all your offices and things, and other ways you can find out more information about the firm. But I also wanted to make sure we had time for Q&A. But Jean, have any other questions come in?
No, I think you are covering everything. I will tell you, there was one question, Gloria Jean, you asked where you can get the COVID addendum. Right now it's up on our website, hhrealtor.com, and that is located under forms and documents. You can find it there. So got an excellent presentation there, John. Lots of kudos here coming in for you. That was a really good presentation. Thank you very much for that. You covered a lot in 1 hour, everything from the CARES Act to closings to property management. So thank you very much for all of that. I also want to just make sure all our realtors know that next Tuesday at 9:30 a.m., the professional development team will be having another webinar here, and we're going to be talking to a couple of local property managers about the local market here, what's going on with our tourism, what should we be telling investor buyers. I think that's going to be very informative as well. So watch for that email coming in. Again, South Carolina Realtors will have the presentation for unemployment next Tuesday. So another webinar day for you next Tuesday at 2, I believe it's going to be at 2 o'clock, but watch for their content there. And John, I just really want to thank you also for mentioning the work of Lindsay Jackson up at our state association and Jocelyn here in our local board, and certainly all our realtors. Make sure, be aware of, the great work that was done by the National Association of Realtors. I will tell you that, you would not have been part of this CARES Act if it was not for the good work of NAR in Washington, D.C., having independent contractors in this. That's pretty unprecedented. And that has really been because of the work that they have done. So, your 3-tier organization has been a team in all this. and has worked hard at every level to make sure that we keep you informed, we keep you part of the process, we keep you in business as much as we can, and that we get ourselves all back into a routine and normalcy real soon on that. So with that, I don't think we have any more questions. Thank you all for attending today. And we hope, again, you'll be part of our virtual program again real soon. John, thanks again for everything. Great job.
Gene, take care.
All right. Have a good day.